Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the independence of Canada's prosecutors from political interference. Recently, the CBC reported that political staffers in Alberta Premier Danielle Smith's office had pressured Crown prosecutors on cases stemming from COVID protests that had blocked the border in Coutts, Alberta. Smith and her staff deny pressuring Crown prosecutors, and an internal scan of 1 million emails found no evidence that staff had contacted Crowns about charges related to the Coutts blockade. However, Smith had previously made statements that she had, to quote, put it to prosecutors and asked them to do a review of cases related to public health order prosecutions. She has now said that she has at no time communicated with Crowns and that her language was imprecise. What exactly does prosecutorial independence mean, and what exactly would constitute political interference in that independence? Here today to discuss this issue are two legal experts, law professor Steven Penney and political science professor Lori Williams. Thank you both so much for joining me today. Professor Williams, I've described what happened in this case, in this Danielle Smith case. Is there anything more in the background that you think we need to know about what happened?
Well, I think it's probably helpful to know that Danielle Smith wrote a column about the SNC-Lavalin matter and the pressure that she saw being exerted by the Prime Minister's office on Jody Wilson-Raybould. And she lamented in her column that nobody had found or provided evidence of criminal obstruction of justice. So it's, I think, important to understand that the standard that we're talking about today is one that she was very strong about imposing on the Prime Minister's office in the SNC-Lavalin case.
Yeah, so let's remind our viewers, Professor Penney, what happened in that SNC-Lavalin case, because that also, there's a parallel here. This is a case that also allegedly involved interference, political interference in prosecutorial discretion.
Yeah, basically what happened there, so far as we can discern, is that pressure was applied by Prime Minister Trudeau and members of his staff in the Prime Minister's office to Jody Wilson-Raybould, who was then Minister of Justice and Attorney General, and therefore had overarching responsibility for the prosecution of this Quebec-based multinational firm that had been charged with basically bribery and corruption under Canadian law. And the concerns expressed basically amounted to, you should try to find a deal, because if you apply the law and end up prosecuting and having this company convicted, it could result in job losses and the economy of Quebec could suffer. And there was also suggestion that the political fortunes of the Liberal Party in Quebec could potentially suffer as a result of this prosecution. Ultimately, Minister Wilson-Raybould refused to buckle under that pressure, and she ended up resigning from the government.
Steven, do you see a parallel between that situation and this current one with Danielle Smith?
Sure, at least at a high level, there's a potential parallel. Now, we don't know all the facts. We haven't received any definitive sort of ruling or finding on whether there was contact between staff in the Premier's office or the Premier herself and any frontline Crown prosecutors, nor are we aware of the precise content, as far as I know, of any communications that may have occurred between the Attorney General and Minister of Justice here in Alberta and the Premier. But assuming, just hypothetically, that pressure was placed on the Attorney General or on individual prosecutors down the line to, stop these prosecutions or consider alternative measures or whatever it may have been, then you do potentially have a parallel with what happened at the federal level recently.
Now, Professor Williams, what's your reaction to the internal investigation that has taken place so far? It was an investigation of these emails. Should we be satisfied by that? I mean, it's only addressing emails, not additional communications. And if it's internal, is that sufficient?
Well, and that's part of the problem. It's not seen as a completely independent investigation, even though it was an independent civil service review. The bigger problem, I think, is that it only investigated or only had access to deleted emails back to December 22nd, and the alleged emails were sent in November. So if they had been deleted, then obviously the investigation would not have found them. The other thing is that it does not appear to have reviewed personal emails. So if there was a communication on a non-governmental email account, that wouldn't have been covered by this investigation. So in the past, when questions like this have been raised, there has been an independent inquiry involving,
Right.
let's say, a retired justice or
Right.
something like that.
We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing prosecutorial independence and allegations that the office of Premier Danielle Smith had interfered in the discretion of prosecutors regarding prosecutions for COVID-related offenses. Now, Professor Williams, can you explain to our viewers what exactly is this concept of prosecutorial independence and discretion and why it is important for our justice system?
Well, it amounts to the rule of law, that everybody be treated equally under the law, and that it not matter if you are a friend or foe of the government, you're going to be treated equally under the law. So it shouldn't matter if the government likes you or your cause and is willing to sort of put its thumb on the scale in your favor. And it shouldn't matter if let's say you've been challenging the government or asking questions about the government, that shouldn't matter either. You ought to be treated under the law based on the facts of the case before you. And because of these public statements that already are seen as putting the thumb on the scale, and now these allegations, there's been direct pressure applied, the question now becomes whether a fair hearing can be provided for the cases that are before the courts.
Stephen, anything you want to add to that to give our viewers a sense of the importance of this principle in our justice system?
Well, yeah, it turns out that this is a very complex area of the law and of policy, and there are somewhat differing views on the precise nature of the relationship between the executive arm of government, including cabinet and the premier or prime minister, and the attorney general, who is both a member of cabinet, but in addition is also supposed to be an independent overseer of the prosecutorial function within the province, or in the case of the federal government, the federal jurisdiction. And there's a debate, I think, and a bit of the lack of clarity in the law as to what counts as improper influence or consultation as between sort of the politically responsible, the democratically responsible executive branch of government and the independent or quasi-independent role of the attorney general. And so it's generally agreed that some degree of consultation and communication on policy grounds, and thinking about what are the effects of either proceeding or not proceeding with a given prosecution or a given type of prosecution is perfectly legitimate. And that's an aspect of our democratic system that ensures political accountability ultimately to the electorate. But of course, a line can be crossed where private partisan advantage can be sought by government, and that is clearly improper. And if that's what happened either in the SNC-Lavalin case or in the case in Alberta, then it would be a very different matter.
Now, Professor Penney, I know that it is possible for governments to say, we want amnesty for this particular type of offense. So cannabis is a great example. There have been big movements to provide cannabis amnesty for people who were convicted of cannabis-related charges prior to the legalization of cannabis. So hypothetically, if the premier wanted to do something like that related to COVID instead of cannabis, how much authority would she have to create a system for that? Now, I'm not saying that randomly calling Crown attorneys and telling them not to prosecute offenses is an appropriate system. I think we can probably all agree that's not appropriate. But what would be within her power to do?
Well, first of all, she would ultimately only have the power, or the government or the legislature of Alberta would only have the power to potentially provide some kind of amnesty with respect to provincial offenses. So, because of the federal division of powers, they would have no authority over criminal code offenses or other federal offenses. But yes, in theory, any government, usually acting through the legislature, through legislation or at least regulation, can provide some kind of amnesty, whether you want to call it a pardon or remission of sentence. In the federal context, you can get pardons with respect to your criminal record, both generally and in the specific case of cannabis possession. But it would require some transparent and democratically accountable process, ideally through legislation, where a certain individual or body would be empowered either on a sort of categorical basis or on a case-by-case basis to grant appropriate amnesty. And that can fall from, it can follow from a particular government's policy concerns. So for example, I don't think there's anything wrong with the government saying, we don't think the full application of this law, which was in effect at the time, and where offenses may have been committed under this law, we don't think it's in the public interest, generally speaking, to prosecute these offenses or to impose punishments for these offenses. If that's done in a democratically accountable way that does not speak to partisan considerations, it's done on a policy basis and it's done transparently. So then the electorate, the voters, can decide whether they agree or disagree with that policy. But something like that could be done.
Right. A lot of nuance here that we're not always getting from the general conversations. We got to go to break, but we'll be back. Welcome back to Canadian Justice, where we're discussing prosecutorial independence and the allegation that Premier Danielle Smith's office had interfered, allegedly, in prosecutorial independence related to COVID-19 charges. Professor Williams, I just want to clarify something I said in the last segment, which is if the allegation relates to the allegations in the CBC story, which are that these staffers had emailed, contacted the prosecutors, the Crown prosecutors on these COVID cases. While we haven't seen the emails, if the allegations are true that they were contacting Crowns and saying, don't move ahead with these charges in this kind of haphazard way that CBC alleges, what is exactly wrong with that? What can you tell us about why that is a problem?
Well, again, it's interfering in a process that's meant to be independent and impartial for a particular purpose, and it looks as though the story seems to suggest on behalf of particular individuals that are favored by the government. So it looks like there is an interference in specific cases, an attempt to make sure that the cases go in a particular direction, based in part on the relationship between the person being prosecuted in that particular case and members of the government. So it isn't, as we heard before the break from Professor Penney, it's not an impartial, transparent process. It's not sort of offering the same benefits to everyone, but rather interfering with specific cases based on almost a personal connection. It's sort of arbitrary rather than consistent and transparent and impartial.
Now, Professor Williams, one of the criticisms that I think the Premier and some commentators have made about the CBC reporting is that CBC did not actually see the emails that they reported on. What should we as the public make of that? Should that be a concern, or is that not relevant? What do you think that means?
Well, I think there have been questions raised. Certainly the Premier, as recently as yesterday, she actually said the CBC lied in the story. She has threatened to sue CBC for defamation, basically calling into question whether they were responsible in their journalism in this matter. CBC has indicated that they went through all the usual procedures. They verified, had corroboration for the statements, and that they stand by their story. That's sort of the information we have. Politically, I think what's happened here is that perhaps the Premier has succeeded in calling into question whether the biased media have attacked her unjustly or unfairly, and that was and has been used in the past, for example, by Ralph Klein, quite successfully in saying, "Oh, look, I'm the victim. I'm being targeted and attacked." And certainly Ralph Klein used it to diffuse questions that were raised around the propriety of some of the things that he did or said.
Professor Penney, one of the things that has been at issue here is the use of the word pardon. I think the Premier actually said that she should not have used the word pardon because it's an American term, but I don't think that that's right either. So what can you clarify things for us? If the Premier wanted to pardon people, what is that something that a Premier can do?
Well, it's something that a government is constitutionally entitled to do in various ways, whether you want to call it a pardon, the exercise of what we call in our sort of ultimately constitutional monarchical system, the royal prerogative of mercy, that these powers exist kind of inherently more at the federal level than at the provincial level. But as I alluded to earlier, in my estimation, there's nothing preventing the provincial legislature from passing laws that would provide for a transparent and accountable system of providing, de facto pardons. It really doesn't matter what language you use for people who have committed provincial offenses, either on a case-by-case or categorical basis. And we know the federal government, as you mentioned, has done this. The problem is that no such mechanism is currently in place in Alberta, and you would have to start from scratch to build such a mechanism through legislation in all likelihood. And it doesn't appear that this government is prepared to do that at this time. And perhaps the Premier was ignorant to that fact at the time she made those remarks. I don't know.
Professor Penney, we've only got about 30 seconds. How many of those offenses that are related to COVID would be federal versus provincial jurisdiction?
Well, the federal jurisdiction offenses would be criminal code offenses. So certainly the very serious offenses that we saw with the individuals who allegedly had firearms and were plotting to commit, acts of terrorism at the border in Alberta,
right.
Those would be very serious criminal code offenses.
But I think
most of the offenses, I think
the public health ones are the provincial ones. We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing prosecutorial independence. Stephen, in the last segment, I had asked you about the power of the Premier in Alberta to grant these pardons and whether the COVID-related offenses that she seems to be concerned with are more federal or more provincial, because she only would have authority to grant some type of pardon through a system for provincial-related offenses. I just wanted to give you a chance to finish your thought there.
Right. Yeah. So the offenses that she's presumably talking about are provincial offenses, because those are the only ones that she would have authority to, if there were a legislative structure in place to grant pardons, it would only be for those provincial offenses. So here we'd be talking about violations of public health orders, mandates, mandatory closures of businesses or religious services, that kind of thing.
Right. Okay. Thanks for clarifying that. Now, I know this is a topic we could have a whole nother program about, but there have been a number of situations recently involving interference with police independence. This actually was a big issue during the convoy protests in Ottawa, because political leaders made a lot of statements about not being able to direct the police to end the protests in Ottawa and also in Coutts. But Lori, what is the rule on that actually? Because it's not quite as clear cut as I think our political leaders were making it out to be.
Yeah, because again, it's that idea of transparency, impartiality, and so forth. So certainly it would be possible for the political branch, the executive or the legislative branch, to give direction to perhaps provide more police in a particular area. You may recall during the Coutts blockade, the Alberta government asked for more RCMP officers to be sent to the Coutts border crossing because of concerns that were being raised there. That's something the federal government could have done. Had the federal government tried to, or any government tried to direct more specifically who ought to be targeted or how the police actually ought to conduct their activities and investigations, that bleeds into the area where it's no longer sort of impartial and transparent, but it looks like sort of a personal or perhaps even arbitrary interference in policing. So the line isn't a clear one, but it's one that has to be tread very, very, very carefully.
Stephen, anything you want to add there? Because I think there's a famous quote from those who are watching the Emergencies Act inquiry from the Premier of Ontario, Mr. Ford, involving a wire brush. So anything you want to add to the independence of police and the ability or inability of politicians to direct them to some degree?
Yeah, I think there is some misunderstanding about that, even by some politicians, at least based on their public statements. Certainly, the responsible ministers, both at the federal and provincial level, do have the authority, explicit legislative authority and constitutional authority to direct the police. So ultimately, in Alberta, for example, the Police Act says very explicitly that all police and peace officers are subject to the ultimate direction of the Minister of Justice and Attorney General. Now, police do have an important zone of operational autonomy, right, where they get to make discretionary decisions about, how and when to deploy force, et cetera. But in terms of the idea that police are entirely autonomous and not ultimately politically accountable to government, that is a myth. It's never been the case in Canada.
Professor Williams, you are a professor of political science, so I want your political take on this. Is there going to be lasting political damage to the Premier of Alberta stemming from this?
I'm not sure we can tell completely yet. And certainly there's been a poll that was done last week, which of course happened after this controversy hit. And the poll results were released this week by Abacus, indicating that the Premier has actually picked up support from some undecided voters. So it's helping, presumably in some constituencies, perhaps hurting in others. By itself, especially with this question in the air about whether the allegations have been sufficiently substantiated, I don't know that we know for sure ultimately what the impact is. If more information comes out and it looks like there is a real weight to the allegations, that there's evidence that is uncontrovertible, and that the Premier may have known more about what was going on than we're currently seeing, something like that could be very damaging. On the other hand, if
Lori,
we're talking about...
Unfortunately, that's all the time that we have, but thank you both so much.
Thank you.
We've heard today about the importance of the principle of prosecutorial independence and about some incidents where our political leaders have allegedly interfered in that independence. What do you think of the allegations in the Danielle Smith case? And what do you think of the reporting on it? Do you think there will be political repercussions, if not legal? You be the judge. I'm Christine, and remember, a freer Canada starts with you.